Since the Revolutionary War began in 1775, the United States filled its military ranks by conscription, more commonly known as the draft. It was a national policy through 6 major wars. And there have been draft resistors in every one of these conflicts. In more recent times, young men have protested in the streets and burned their draft cards. But much earlier, during World War I, American socialists distributed a leaflet that questioned the constitutionality of the draft and tested the boundaries between free speech and national security. It resulted in an important Supreme Court case, Schenck versus the United States.
Hi, I'm Doug Ginsburg, and I'm a federal judge. As a nation, we revere our First Amendment rights. But the case of Schenck versus United States put a serious limitation on our right of free speech. In 1917, Charles Schenck, the General Secretary of the Socialist Party, was authorized by the party to distribute 15,000 leaflets urging the public to disobey the draft, and he did. The Socialists declared in their leaflet that the draft violated the 13th Amendment of the Constitution that prohibited involuntary servitude, which was a polite way of saying slavery. Earlier the same year, the Congress had passed the Espionage Act of 1917. The act made it a crime to convey information intended to interfere with the war effort. By attempting to cause insubordination in the military and to obstruct recruitment, Schenck was charged with undermining the war effort and convicted of violating the Espionage Act. He appealed to the Supreme Court. The critical question was, did Schenck violate the Espionage Act by criticizing the draft, or did the Espionage Act violate his First Amendment right to freedom of speech? The First Amendment of the Constitution states, Congress shall make no law abridging the freedom of speech. The justices reasoned that the courts owe greater deference to the government during wartime, even when constitutional rights, such as those in the First Amendment, were at stake. After oral arguments and deliberations, the decision was unanimous, 9-0 against Charles Schenck. Justice Oliver Wendell Holmes, Jr. wrote the opinion, and he was joined by all of the other justices. In his opinion, Justice Holmes introduced the clear and present danger test. He argued that speech could be limited if it posed a significant risk of causing harm, much like falsely shouting fire in a crowded theater. Schenck was clearly a limitation on free speech and even political speech, but over the next 52 years, the Supreme Court gradually phased out the clear and present danger standard, even during wartime, until it reached the conclusion that all political speech is protected from the government unless it's an imminent incitement to violence. Otherwise, anything goes. Speak your mind.
Schenck versus United States was decided in favor of the federal government by a 9-0 unanimous vote in 1917. The key principle was the First Amendment, freedom of speech. The Supreme Court held that Schenck's actions did violate the Espionage Act and did not violate his First Amendment rights, and the court created the concept of clear and present danger. Speech creating a clear and present danger was not protected by the First Amendment and could be limited.